Hello guys, I'm Shreya and I welcome you all to my channel Knowledge Info. Today in this video, I'm going to be discussing one of the very important topics which deals about punishment for attempting to commit offences which are punishable for life imprisonment or other imprisonment. I'm talking about section 511 of IPC, which is one of the last sections of IPC and it is given under chapter 23 of IPC. It is one of the very important sections, so I am going to be discussing this section in greater detail. I am going to be talking about its definition, meaning, essential ingredients which constitute this offence. We will be discussing attempt as an inchoate crime or incomplete crime, its applicability, why it is punishable under IPC, and the tests which are used to determine whether an act falls under the situation of preparation or attempt, with some referring case laws and lots more. So without any further ado and blabbering, let's move towards our video. Firstly, we will be discussing about the definition of attempt as per section 511 of IPC. Basically, attempt is nowhere defined in Indian Penal Code, but section 511 of IPC deals with the punishment for attempting to commit offences. So let's first understand the language of this section, which says, whoever attempts to commit an offence punishable by this code with imprisonment for life or imprisonment, or to cause such an offence to be committed, and in such attempt does any act towards the commission of the offence, shall, where no express provision is made by this code for the punishment of such attempt, be punished with imprisonment of any description provided for the offence for a term which may extend to one half of the imprisonment for life, or as the case may be, one half of the longest term of the imprisonment provided for that offence, or with such fine as is provided for that offence, or with both. Which basically means that a person is punished for an attempt when he has taken any step after preparation which is proximately connected with the commission. Which means that a person has taken any step which leads towards the commission of the crime after preparation. Which means that attempt in general meaning is said to be an effort to achieve tasks or activities. An attempt to commit a crime occurs when someone tries to commit a crime but fails in his attempt. It is also being said under this section that an attempt is punishable by law. It is well established in the IPC that first there is the intention of committing a crime occurs, and then preparation to commit and attempt to commit every crime. Preparation does not mean the completion of a crime. If a person accomplishes the third stage, that is the attempt, then only the crime is said to be completed. And whosoever is being found committing such a crime is punished with imprisonment of any description which may extend to one half of the life imprisonment or one half of the longest term of imprisonment provided for that particular offence of which the attempt has been made, or with such fine as is provided for that offence, or with both. Let's understand this with a particular illustration. For example, if A makes an attempt to steal some valuable things by breaking a box, and after opening the box he finds nothing there in it. In this case also, no crime is being committed, but still he is punishable under Indian Penal Code because it is considered that he has made an attempt to commit a crime. Now we will be discussing the meaning of attempt in general sense. An attempt has been seen as the direct movement to commit the crime after the preparation has been done. An attempt can also be defined that if a person has done an intentional act to seek a certain objective means the completion of the crime, and if that objective fails due to some reason that is independent of his own will, then only it is said that a man has attempted to commit the crime. An act will be considered accomplished on the basis of two things. First, it must be made sure that the act is seen into completion must be adopted, and it must be beyond preparation, which means that the act which the accused has done must be beyond the preparatory stage in the commission of the crime. Now let us discuss the essential ingredients which constitute the offence of attempt. In the case of Abhayanand Mishra vs. State of Bihar, Supreme Court has determined the following essential ingredients of attempt, which are as follows. First is intention, which means that there must be an intention to commit a crime must be possessed by the accused. The second is taken a step forward, which means that there must be some act which must be done by the accused in furtherance of that intention or towards the accomplishment of that crime. Third is, he failed to commit that crime, which means that the act committed by the accused must be an incomplete act or an incomplete work, or falls short of a completed crime, or it is being left at the stage of an inchoate crime. Hence, it can be said that if the above ingredients are fulfilled, it is evident that the act done was an attempt to commit a specific crime, and it is held to be punishable under Section 511 of IPC. Now we will be discussing that how attempt to commit a crime is an inchoate crime. The term inchoate means underdeveloped or just begin or at the early stage, or simply it can be said that inchoate crime means an incomplete crime. As we know that inchoate offences cannot be understood in isolation, which means that inchoate offences cannot be understood separately. It has to be read with other substantive offences, that is independent offences, in order to be applied. A characteristic feature of these inchoate offences is that they are committed even if the substantive offence does not reach a stage of completion and no consequence results. Thus, if the offence of crime has not been completed, even then a person can be guilty of an attempt to commit a crime. As we know that actus reus and mens rea are essential elements for the completion of a crime. Mens rea means guilty intention and actus reus means a guilty act followed by the guilty intention. Here, actus reus to commit a crime is not completed, but mens rea to commit the same crime is completed in an attempt. Therefore, attempt itself would be said to have been completed at this stage, which means that an attempt is an inchoate crime, as the mens rea element is completed, but the actus reus is not satisfied in the completion of crime, yet it is punishable under IPC, therefore it is an inchoate crime. Now we will be discussing about the applicability of Section 511 of IPC. It was being held by the Supreme Court in the case of Satvir Singh vs. State of Punjab in the year 2001 that Section 511 is applicable only to the attempt to commit such offences which are punishable with imprisonment for life or with other imprisonments. It was being held that Section 511 provides that whenever any person attempts to commit any offence that is punishable with imprisonment for life or other imprisonment, where no express provisions has been made in IPC for the punishment of such an attempt, such person shall be punished with imprisonment of any description provided for the offence attempted to be committed by him for a term which may extend to 1/2 of the imprisonment for life, or as the case may be, 1/2 of the longest term of imprisonment provided for the offence being attempted by him, or with such fine as is provided for as a punishment for such offence, or with both. Now the question arises that when an attempt to commit a crime occurs. An attempt to commit a crime occurs when a person makes a proper mindset to do a criminal act and put a step forward for fulfilling by arranging the means and methods necessary for the commission of that crime. But ultimately he fails to do so, which means that the commission fails. Then we will say that the person has attempted to commit a particular crime. Now let us discuss that why is an attempt to commit a crime punishable under IPC even when no harm is necessarily being caused to the victim. An attempt to commit a crime is a crime under Indian Penal Code. Every attempt falls short of success must create a threat in the mind of people, which by itself is an injury, and the moral guilt is being created in the mind of the offender is the same as if he had succeeded. According to Section 511 of IPC, only half of the punishment is being awarded because the injury is not as great as if that crime has been committed. Therefore, it is being punished under IPC in order to prevent offenders from attempting the offence again, which helps to keep the society more safer. Let's now discuss that what punishment is being imposed on the accused when he is found guilty for an attempt of a particular crime. IPC punished attempt through 4 ways. First is same punishment at attempt and completion, which means in some cases the same punishment is awarded for the attempt and commission of a particular crime. Second is separate punishment for attempt of the offense and the offense itself. Example, murder and attempt to murder, which means an attempt to commit offense and the commission of the same offense both have separate punishment in Indian Penal Code. Example, section 302 dealt with punishment of murder and section 307 dealt with an attempt to murder. Third is only attempt is punishable and crime is not punishable. Example, suicide, which means that there is only one crime in the entire Indian Penal Code of which only attempt is punishable and the crime is not punishable. That is section 309 of Indian Penal Code, which deals with punishment of attempt to commit suicide. Fourth is if no specific provision provided for attempt, then it will be punishable under section 511 of IPC, which means that there are some cases where no specific provisions are made regarding an attempt. Section 511 of IPC deals with such types of cases, which provided that accused shall be punished with half of the longest term of imprisonment mentioned for the offence or with fine mentioned for offence or both. Now let us discuss that when does preparation of an act ends and attempt begins. The Supreme Court in the case of Aman Kumar vs. State of Haryana 2004 held that the word attempt is to be used in its ordinary sense. There is a difference between intention to commit an offence and preparation. It can be said that where attempt begins, the preparation ends. It means that when any step is taken towards committing a particular offence, then it is considered as ends of preparation and begins of attempt. Now we will be studying certain principles which are being used for determining that whether an act amounts to mere preparation or an attempt to commit a particular offence. Basically, we will be studying that at what stage an act or series of acts is done towards the commission of act intended would be an attempt to commit an particular offence. So let us discuss some of the tests in order to understand this issue. The very first is the proximity test, which is in relation to time and action or to do an intention. The proximity test examined that how much the defendant is close to completing the offence. This test basically states that an act or series of acts is considered an offence if all the essential steps that constitute the crime have been committed and the only consequence of the crime has not taken place. The act of attempt should be sufficiently proximate to the crime. It should not be a remote act. Remote act means an act which is far off the crime. The act should place the accused in direct relationship to the victim and should have contributed to the final act. This was held by the Supreme Court in the case of Abhayanand Mishra vs. State of Bihar in the year 1961. In this case, the accused falsely showed that he was a graduate. He attempted to appear as a private candidate in MA examination through a prior permission letter but was debarred from appearing in the same and prosecuted. In this case, the court held that the attempt to commit an offence begins when all the preparations are complete and he takes a step towards the commission of the offence. It does not matter if this direction towards the commencement fails due to external factors, but it is still an attempt. The next principle or the next test is locus ponentia test, which is also known as the time for repentance test. This test or maxim means that the law provided time to every offender before he is in the grips of the law. If he is still in the stages in the process of crime where he can undo his crime and not continue with his crime, then the law cannot punish him. If he continues to follow through with this criminal plan or design, then it will be said that he has crossed the stage of preparation of crime. It basically means that in order to apply this test, it is necessary that the accused must not be in a position to revert back from his action. That is, he must not be in a position to have the time for repentance, or he must not be in a position to discontinue his commission of crime. It can be clearly seen in the case of Malkit Singh vs. State of Punjab in the year 1970. In this case, a truck carrying paddy from Punjab was stopped by a sub-inspector and was taken into custody around 18 miles from Delhi border. He was accused for violating the Punjab paddy order. The driver himself admitted that he was transporting the paddy to Delhi. The court held that the driver was not guilty of violating Section 7 of the Essential Commodities Act and the Paddy Export Control Order, as he still has not crossed the stage of preparation and still had time to change his mind. The court commented in this case that preparation consists of arranging the means necessary for the commencement of the offence. On the other hand, attempt is the direct movement towards the commission after preparations have been made. Therefore, the court held in this case that if the offender has the time to change his mind, then his act would be rendered harmless. The third principle is res ipsa liquitor test, which is also known as the unequivocality test. This test basically means that the thing speaks for itself. It is applied depending on the facts of each case independently. To constitute an attempt, the act must be as such to clearly and undoubtedly indicate the intention to commit the offence. The act must be referred to the commission of the crime and it must be evident and clear on examination. The intention followed by preparation is not sufficient to constitute an attempt, but intention and then preparation must be followed by an act towards the commission of the crime must be considered as an attempt. This test can only be applied if it is being proved by the facts and circumstances of the given case that the accused had the clear intention to commit the particular offence. It can be clearly seen in the case of Om Prakash versus State of Punjab in the year 1961. In this case, the accused husband deliberately starved his wife to accelerate her death. It was held that this act had amounted to attempt to commit murder under section 307 of IPC. The court held that a person commits an offence under section 307 when he has an intention to commit murder and acts towards the commission. The court made a differentiation between the intention to commit an offence and the intention or knowledge necessary to make an act an offence. As it is being clearly said or mentioned in section 511 of IPC that the expression whoever attempts to commit an offence means whoever attempts to commit any act with the knowledge necessary to commit the offence. It is similar to the expression which is given under section 307 of IPC. The next principle or the next test is social danger test. In order to distinguish criminal attempt from preparation, the following two factors are contributed. The first is seriousness of the crime attempted and the second is apprehension of the social danger involved. In this test, that is, in social danger test, the accused's conduct is not examined only partially, but the consequences of the circumstances and the fullness of the facts are taken into full consideration. For example, if A administers some pills to a pregnant woman in order to procure abortion, however, since the pills are not poisonous, they do not produce the result. In spite of this act, he would be held liable for attempt from the point of view of the social danger test, as his act would cause an alarm to society causing social consequence. As it can be clearly seen in the case of State of Maharashtra versus Mohammad Yaqub in the year 1980. In this case, the accused tried to smuggle silver out from India. They were convicted for the violation of the Foreign Exchange Regulation Act, Import as well as Export Control Act 1947 and Customs Act 1962. While the appellate court acquitted the accused, the Supreme Court of India convicted them for an attempt to export silver. The court held that for an act to be considered an attempt, there must be three ingredients. First, there must be an intention to do the act. Second, some act must have been done which would have been done towards the commission of the act. And the third, the act must be proximate to the crime. Proximity is not with regards to time and place, but with regards to intention. The act must show an intention that is distinguished from mere desire or object to commit the particular offence. It must be seen by the facts and circumstances of the case and not necessarily in isolation. They also established that what constitutes an attempt depends largely on the facts of the case. The next principle or the next test is impossibility test. It means that if a person attempts to commit a crime which is impossible in nature, even then he is punishable under the Indian Penal Code. For example, if a person attempts to kill someone by empty gun or steal something from an empty pocket or steal jewels from empty jewel box, even then it is considered as an impossible attempt of committing that crime, but here an intention to commit the crime is present and also a step is taken towards the completion of that crime. Thus it is considered as an attempt to crime under section 511 of IPC. It also basically means that this test will be applied if a person tries to commit the crime whose commission is impossible in nature. It can also be seen in the case of Asghar Ali Pradhania vs. Emperor 1933 that the appellant was convicted under section 312 read with section 511 of Indian Penal Code of an attempt to cause miscarriage. The complainant was a divorced woman who came to be impregnated by the appellant on the promise that he would marry her. He was married with children. He wanted to cause miscarriage and tried to administer a liquid for it. On her making noise, her father and others came out and the appellant fled. On investigation, it was found that he was trying to administer was copper sulfate in less quantity than was sufficient for causing miscarriage. But he was trying to do a very dangerous act, although the quantity was insufficient. Therefore, it was held that the accused was still liable for causing miscarriage, even though the act he was trying to commit was impossible to happen in nature, but the act was sufficient to create alarm in the society. Therefore, as a concluding part, we can say that by studying the certain cases in this video, we can say that there is a difference between attempt and preparation. To conclude, we can say that for a person to go from a stage of preparation to a stage of attempt, he must have passed the stage of preparation completely and there shall be no chance of turning back. There should be the existence of three major ingredients, namely the intention to commit the crime, an action must be done towards the commission of the crime, and the crime must be proximate and not too remote to the crime. So with this, we ends up with our video. If you have any suggestions regarding my video, do let me know in the comment box section. And if you like my efforts which I tried to pour in this video, do like, share and subscribe to my channel. Don't forget to press the bell icon parallel to the subscribe button in order to get notified when I will upload my further videos. So it's the time to leave now. So until we meet again, stay home, stay safe, do take care of yourselves, do take care of your families, and there's a goodbye. Thanks for watching.